I'm sitting, which is unusual for me, you know, it's because this is a very serious topic. Okay? This is something that affects each and every one of you. In fact, just moments ago, when we were at lunch, I was sitting in here going over my presentation, my notes, and a gentleman walked in he's an attorney. He's also a chef instructor at a community college. He grew up in the business, and he was curious to see what was going on. And he says, oh, yeah, I also used to do harassment training. I did it for the National Restaurant Association. He said, funny, we're doing this. And one of the things that we agreed upon so quickly is how important it is, because you can lose your business. How important it is, Rich, you as a manager can be sued personally. It's unbelievable. When I was a manager on the floor, I used to think that it was just touching, right? Or, you know, it was job benefit for a little trade, if you know what I'm saying. I am so fortunate, I will use myself as an example as often as possible, that I never got sued or named. I was an improv comic on the floor. I don't tell jokes, I do voices. You've seen, I'm a moron. But I have a blast being one. I was on the floor. I built business because I was basically a little comedy act going from table to table to table. I had a blast. Staff had a blast. I mean, when we talk about, tomorrow I'm going to talk about how play is so important in your place. I played and had a blast. But I am so lucky that I didn't, or at least if I offended someone, they never said anything. Okay? Now with that said, I want you to turn to page 78 in your books, otherwise L1. I want you to take 2 minutes and answer the quiz. Read the questions and answer the quiz. Okay, we'll stop wherever you got right there. That's where you've gotten to. Turn the page to L2. This is one of those times where I'm going to read as opposed to talk off the cuff, because now we're talking about legal information. We're talking about things, again, that affect your restaurant more seriously than anything else. We are now in a day and age where even 5 years ago, I wouldn't have recommended this, but about 4 years ago I started. And that's purchasing EPLI insurance, Employment Practices Liability Insurance. Employment Practices Liability Insurance. Yes, that means we're going to lose yet another piece of our margin, another nickel, another something. However, it's to protect us against lawsuits when it comes to harassment, wrongful termination, hiring, discrimination, you name it, gender. It's worth protecting your assets. Now on L2, I'm going to read this. Sexual harassment is a form of sexual discrimination that violates Title VII of the Civil Rights Act of 1964. Continues, the EEOC, that's the Equal Employment Opportunity Commission, right? The EEOC defines sexual harassment as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of sexual nature constitutes sexual harassment when submission to or rejection of this conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with the individual's work performance, or creates an intimidating, hostile, or offensive work environment. Mouthful, isn't it? Now let's talk about what that means. Sexual harassment can occur in a variety of circumstances, including but not limited to the following. The victim as well as the harasser may be a woman or a man. The victim does not have to be of the opposite sex. The harasser can be the victim's supervisor, an agent of the employer, a supervisor in another area, a co-worker, or a non-employee. The victim does not have to be the person harassed, but could be anyone affected by the offensive conduct. Unlawful sexual harassment may occur without economic injury to or discharge of the victim. The harasser's conduct must be unwelcome. If one thing didn't pop into your brain, I'll be surprised when I said that a non-employee can create a sexual harassment situation in your restaurant, and that you are responsible. You are responsible for creating a safe, non-hostile work environment. Think about that. You got that regular that sits at the end of the bar and tells all the corny, dirty jokes? You mean I'm responsible to shut him down? Yeah, you are. There are 4 types of sexual harassment. Number 1, a supervisor demands a sexual favor of a subordinate in exchange for tangible job benefits such as hiring, promotion, job training, or job retention. This is referred to as quid pro quo. This for that. You give me a little of this, I'll give you a little of that. Right? I mean, that is tit for tat, same thing. We're talking about, that's what most of us think about sexual harassment, right? The casting couch in Hollywood, right? You want the role, sleep with the director. Well, same thing happens in our industry, happens all the time, and that's the easy one to understand. It's where we get into these next 3 areas where you go, uh-oh. Number 2, when the sexual harassment creates a hostile work environment, even though it does not result in a tangible job detriment. The hostile work environment can be created by a supervisor, co-worker, or even a non-employee. Supervisor, co-worker, or non-employee. Hostile work environment. Let's talk about some of the things this means. Hostile work environment. Those of you who have bars, do you get offered by the beer vendors and liquor vendors some of those, posters, things to put up in your place in the kitchen and stuff of women in bathing suits? Anytime you introduce sex into the workplace where it does not belong, it is potential for a hostile work environment. Where would a picture of a woman in a bathing suit be appropriate? Well, in a business. Maybe a bathing suit store, but probably a gentleman's club. About the only place I can think of. Doesn't belong in your restaurant. What about the cooks who have the boombox in the kitchen playing songs with F this, F that? What about a beefcake picture? Forget about the woman's side. What about if there's a picture of a couple guys advertising some food and they gave you the poster? It's inappropriate. We're introducing sex into the workplace. That means for employees, telling a dirty joke, talking about who they slept with last night at the POS terminal. Happens every day, doesn't it? Dude, I hooked up. Not to mention your customer hears it all. I mean, it's just not acceptable behavior. Non-employees, we talk about those regulars that tell the dirty jokes. That's a hostile work environment. Now here's real interesting, and it kind of falls into quid pro quo, and it falls into a hostile work environment. I don't have to be your supervisor. It's anybody who has control over someone else. I'm a cook, and I want to date. I want to date with Debbie. Debbie, go out with me. No. I'm not going to give you food for table 42 until you go out with me. You say you're going to go out with me. Is that a control position? Is that a this for that? Is it a hostile work environment as well? I mean, think about what goes on in your restaurant, and we'll talk about what you're responsible for. How about a hostile work environment? I'm in the middle of a shift. We're in the line, and curse words are flying. Is that a hostile work environment? Maybe not. Maybe in the heat of the battle, it's okay. But you know, after the heat of the battle's done and there's curse words flying, it might be. Because here's the one thing I want to tell you about a hostile work environment. It's not whether it's a bad word. It's not whether it's a picture. It's not whether it's a joke. It's not whether you made me uncomfortable in advances. It's that it makes me feel uncomfortable. Yesterday it was okay. Today it makes me uncomfortable, and today you have violated. And then it's up to a jury of your peers. You got a 50-50 shot. 50-50 shot. One jury might say you're okay, another jury says, no, you owe $1 million. Debbie.
Then is that a fallacy when they say the person has to say that it offends them? In some form or fashion, they have to acknowledge that it offends them?
Is it a fallacy that somebody has to say it offends them to be harassment? Yes, it's a fallacy, because they don't often tell you. They do not often tell you. It is your responsibility, and again, I'll get ahead of myself, to have a safe environment for my people to be in. And part of safe is I don't feel uncomfortable. Now, wait a second. Let me use myself as an example. When we had the multi-unit brew pub, I got promoted into an operations role, and Susie, my wife, was a server. I was moving to another location. The day that I got promoted is the day I asked her out. Is that harassment? Potentially? I'm going to go to another location. Oh yeah, if it went wrong, I was dead to rights. With that said, Michelle, I ask you out on a date. I'm your boss. Is that harassment?
Not if I accept.
Forget about you accept. You say no.
No.
I can ask. I ask you again. Is that harassment?
Yes.
All right, because you feel uncomfortable now. I've already told you no. Now I'm badgering you. And it builds and it builds and it builds. So fraternization's okay. It's okay to ask. You can create a policy that says it's not okay, and you will terminate if you choose. If Susie and I work together, and we bring a fight from home into the restaurant, is that harassment? If it makes other coworkers uncomfortable that we brought our private lives into that restaurant, and it has a sexual nature or just that tone, yeah, it's harassment. Pictures, jokes, right? Let's turn to, I gave you a second packet, separate packet. We're going to turn to page 3. I'm going to show you that this stuff happens. Yes, Robert? Something goes on and you don't know about it. If you have no idea, you're fine. But listen to this. You're walking down the hallway to back to the line in the kitchen. And off on the back door, as they're exiting to go have a cigarette, you hear the dirtiest joke. Just the punchline. You have a responsibility to go cut that off right now. Pull the person aside and let them know that is not acceptable. You can't pretend you don't know. But if you don't know, you can't be held responsible.
I just go off the question that someone asked us about if they don't tell you, because we had a situation where an employee was harassing another employee. When they And yet we had no, I don't think, any reasonable way of knowing that it was occurring.
It doesn't mean you won't get sued.
No one ever said a word.
But once you find out, you have a responsibility to react, and we'll talk about that. But bottom line is, even if you do everything to the letter of the law, you're still going to get sued. It's about making sure you're clean.
The law does read that it's known or should have known.
Known or should have known is what he says the law is. So this is where we'll talk about putting procedures in place that people can notify you. All right, and notify somebody. But let's go to page 3, bottom, handwritten number 3. This is about a hostile work environment. I'm going to withhold the restaurant's names. You have it written, but I'm not going to record it. 2 Florida restaurants pay $525,000 for sexual harassment of teenagers. The EEOC lawsuit against a pizza place in Florida charged this company with subjecting female employees to a sexually hostile work environment. The EEOC contends that the sexually harassing conduct created by the restaurant's manager was primarily directed towards 2 sisters who were ages 16 and 17 at the time. They were employed with this company. The conduct included inappropriate touching as well as egregious verbal comments. The $325,000 in mandatory relief includes a $100,000 fund to be distributed among other similarly situated female employees subject to the sexually harassing conduct. This lawsuit was January of 2004. Once you turn to page 9 of this handout. This is harassment by a non-supervisor, a hostile work environment. EEOC sues a Rockford restaurant for sexual harassment. The EEOC said that its administrative investigation, which preceded the lawsuit, revealed that the harassment, which was carried out by a male server and observed by other employees, involved almost daily proposition and explicit sexual remarks which were graphic and offensive in the extreme, as well as the man physically grabbing the woman. At one point while at work at this restaurant, in front of other servers, the man recounted a dream he claimed to have had in which he and the server were having sex. After the server married, the man escalated his harassment and told her, "I can do a better job than your husband," and graphically described his sexual desires. This is a lawsuit for July of 2003. This is real stuff. These are the things that got to the EEOC. These aren't the things that were settled. And it happens all the time. As a franchisor, in my position as a franchisor, we get named all the time. When I say all the time, at least once a year, one of my franchisees is getting sued. Candy.
Personal experience, what happened is I had a situation 20 years ago, 15 years ago. Everybody joking around, everybody having a good time. Got in the middle of a divorce. Somebody got pissed off at one. I had 27 past employees sign up for a sexual harassment. That went back on, and they went back, and they went after me.
What she's saying is, once there was an employee, if I paraphrase properly, or an ex, somebody that was thankfully no longer married to her, harassed people after a divorce. 26 people, 26 past employees, past and present, came back, filed a lawsuit with the EEOC for sexual harassment. There is at least a year, depending on the state you're in, they can. You think you're done, they're gone on the 364th day file, and it comes out of left field. This stuff happens. It happens. Let's go back to our page L2 of our workbooks. Gender harassment is where individuals are harassed just because of their gender. Gender harassment. This is a strange one. Those of you who think you're being very nice, chivalrous, and have your employees' best intentions at heart, do not raise your hand, just in your brain answer. Who has said, no female manager will close because it's late night, I don't want them to be in a dangerous situation, so make sure if a woman manager closes, somebody's with them? Broken the law. It should be no manager closes alone, even though your heart is in the best place. That's gender harassment. Because I'm a woman, you think I can't do the job. You're going to treat me differently. Right? Let's go to the handout packet and go to page 5. This is about gender harassment. Judge awards damages against this crab restaurant in the EEOC sex discrimination lawsuit. The EEOC lawsuit alleges that this restaurant's hiring practices from October of 1986 through December of 1995 had a disproportionate impact on the hiring of females for the position of food server. This restaurant unlawful employment practices resulted in the hiring of male applicants for 108 consecutive openings for waiters and waitresses. The ruling is a huge victory for women in general and female waitstaffs in particular, said the EEOC chairman. The decision sends an unequivocal message to the entire restaurant industry that it is not acceptable to reserve the most coveted and highly paid waitstaff positions at prestigious restaurants for men. I know you all saw this on 60 Minutes. I know you all know this restaurant. This is a restaurant that they're heavy, heavy trays, and they hired whoever they could get. It just happened to be men. And the EEOC got their fingers in it, and do you know what? They oversee all of their hiring practices every time they hire. They are in their back pocket, they're in their back door, they are just absolutely a nightmare. And the truth of the matter is, with this restaurant, it had nothing to do with, I'm only hiring men. That's all it would take, the position, because they were heavy, heavy trays. But bang! Michelle. Doesn't make it legal. Let me put it for instance. Scottsdale, Arizona. How many people have been to Scottsdale, Arizona? How many people have been to one of the restaurants in Scottsdale, Arizona? Is it not filled with the prettiest people you've ever seen in the front of house? I keep waiting for one of these places to get nailed. You're kidding me, right? Think about this. Hooters. Somebody brought up Hooters. Hooters won their lawsuit because of gender harassment was acclaimed. Hooters hires women because they got approved that basically through the courts, that's their theme. But they did get a judgment that says you have to hire male hosts and female cooks. It's wacky. So if you look at your staff, also when we go into outside, just regular harassment, which includes race, gender, outside of sexual harassment. Think about if your kitchen is imbalanced on a nationality, if your front of house is imbalanced with male, female, all the different positions, you are potentially opened up. Will it happen? I don't know. It takes the one person. What we are talking about is it takes one person, the one day, the one instance. That's it. It's tough to protect yourself, isn't it? Because it's that one time, one instance, my feeling. Don't care what your interpretation is, it's how I feel. It's how I feel. Even though yesterday I might even told that joke. Today it bothered me. Let's go back to L2. This is my favorite one that should just go, retaliation, where individuals are punished for alleging sexual harassment. Somebody comes up to you and says, John has harassed me. You investigate. It's a lie. So now you're going to get me. You're going to write me off the schedule. You're going to fire me. You're going to tell other people. Guess what? That's called retaliation. And now you are guilty of sexual harassment called retaliation, even if anything never happened. I invented it. You got to be really careful. Let's turn to page 7 of that handout. It's about retaliation. EEOC settles sexual harassment lawsuit with this major chain. In the lawsuit filed on September 3, 2002, the EEOC claimed that this restaurant's general manager and a male coworker sexually harassed a high school student hired as a waitress in April of 2000, and its restaurant at this address. The EEOC also alleged that this restaurant retaliated against its former employee after she complained about the unwelcome harassment by reducing her scheduled hours and terminating her employment. They only lost $135,000. It's a lot of breakfast. And this restaurant has other problems, if you remember in the news. Let's turn to L3. Now let's talk about what we can do. What is manager's responsibility for preventing discrimination and/or harassment? The manager wants to avoid a lawsuit because why? A, they're expensive. 2, discrimination/harassment is a violation of company policy. Remember that HR stuff we just went through? We need to have not just a sexual harassment policy, but a harassment policy, and it needs to be reviewed by your attorney at least every other year because the laws change. And the manager wants to make sure you avoid a lawsuit because you can be sued personally. There is no corporate shield in this, folks. It's pierced immediately. You as an individual, manager as an individual, anyone involved can be sued personally. No corporate shield. I don't care if you buried it into 5 corporations, they're finding you. The manager's responsibility is to, 1, take steps to prevent sexual harassment and/or discrimination. Let's go back to that handout I gave you, page 1. This is a lawsuit because someone failed to implement corrective action. EEOC wins $1.55 million jury verdict in sexual harassment suit against Florida restaurant. The EEOC lawsuit filed in 1999 said that former waitresses and hostesses were subject to egregious acts of verbal and physical sexual conduct on the part of one of the employer's assistant managers, and despite repeated complaints to management, the corporate defendants failed to take necessary steps to stop the harassment. The harassment of the young woman included touching, groping, and rubbing their breasts, legs, and buttocks in sexually offensive manner, forcing the women to sit on the assistant manager's lap before leaving their shifts, attempting to kiss them, and making graphic, offensive sexual remarks to them. EEOC asserted that the woman repeatedly complained to management about the sexually offensive conduct. However, the corporate defendants failed to implement corrective action, allowing the behavior to continue and escalate. Major chain. Let's go back to L3. When discrimination and/or harassment are found to have taken place, basically, you must take immediate, corrective, remedial action. That's immediate, corrective, remedial action. What is immediate?
Instantly.
Right now. It's to your attention. You start in motion. My first call is to my attorney. Do not do this on your own. You mess this up, you lose your restaurant. Pay the $280, $300 an hour, best $300 you'll ever spend. $300 today, $900 a day, $1,000 today is going to save you $1 million tomorrow in your family's future. Corrective remedial action. It's got to be corrective. Now, here's the deal. As we go forward, you're going to play judge and jury. And you're the scales of justice. You're going to be forced to make a determination if it happened and give a punishment or not that's equal to the crime. It's a lot to ask. But if you do it wrong, you're in big trouble. A, preventing sexual harassment. You must have a policy statement. We've already said that, right? If you don't have one now, go get one. Must communicate a policy statement. You have to train your people that it exists. You have to tell them about it. Must show by example that the policy statement cannot be violated. Don't make it so tough that you can't walk the talk. If you're a joker and love to tell dirty jokes in your restaurant, you put no dirty jokes on there, and you're telling dirty jokes, how good is your policy? You just voided it. Voided it. You have no protections. So when something happens, you say, I did it right, see? You've demonstrated in the past that you don't follow your policy. It is worthless. Forget even if you followed it properly. Hold workshops with supervisors and managers. You mean what we're going over right now and what you're learning, and this little handout inside your workbooks is now your training tool, and I need to be training my management? Yeah. Out of the box. You do nothing else and rip these pages out and photocopy them and use them and do your trainings, and I would do it quarterly, minimum twice a year, because you have to demonstrate how important it is to your organization. You need to provide a mechanism for employees to complain and not have to complain first to their supervisor. Duh. Right? Bob's harassing me. Bob, stop. Oh yeah, like that's going to happen. So you have to have in your policy that they have the ability to go over Bob's head to the manager above Bob. All right? If he's an assistant manager, it's now general manager or another manager. And this is our process. What happens if it's the owner? Where do they go? EEOC. And man, you don't want the EEOC in your business, because they will go back to all of your past employees. And this is the government. They'll spend more money investigating you than they'll get out of your pocket. And it'll be ugly. And even if they determine that you're okay, they're going to stay in your place and start to monitor you and make sure you're training and make sure you're documenting, make sure that none of this ever goes on, because now you're on their radar screen. And they continue to call your current employees, how's it going? You realize that? You're never off the hook. You don't even want them in there, so you need to make sure that you prevent it. B, immediate corrective remedial action. Let's talk about that. Number one is investigate. That means we take a statement from our complainant, a statement from our alleged perpetrator, and other coworkers. I got to go talk to all these people and take a statement. I've got to get the information. Then I got to make a decision. Did it happen or did it not? You make the decision. There are some people who will spend money on an outside service to actually do the investigation. But the amazing part, after you document, that's the next thing. There's one that will just blow your mind when you start thinking about the restaurant business and what goes on. You have to resolve with an action reasonably calculated to end the sexual harassment or discrimination. Reasonably calculated. For instance, I have a guest that has now pinched my server's rear end. One reaction would be, get the hell out, right? Goodbye, I do not need your business. I think that's pretty appropriate, don't you? I have a customer who tells a dirty joke and offends the server. It might be hey, Eric, will you take that table? That might be appropriate. It might be that I've got another server who's harassing, or a kitchen person harassing a server to go out on a date. It could be simply making sure they never work the same shifts. How would you ever know what the appropriate action is? You have to do what? Ask the person, what would you like to see happen? Before you do your investigation. Otherwise, you could miss the mark. Because you may have terminated the person and said, I didn't want you to terminate him, I just didn't want to see him. Vice versa. Are you kidding me? All you did was suspend him for 3 days? And now I'm going to the EEOC. Even though you did what you thought was right. Next, you need to inform the complainant and urge further communication as necessary. So you've made your decision, you documented. You now go to the person who brought the claim to you and tell them what you're doing. We are suspending the person. We are making sure you don't work together. We are firing them. We don't believe it's happened. Please keep us informed. If you don't believe them, you don't believe them. Isn't it a stinky place to be? That's where we go back to, I'm calling my attorney. Before I ever talk to an employee, I'm spending $300 an hour, happily. And not just an attorney, I'm calling a specialist. I'm calling an HR attorney. Stacy, would you agree with me? Oh yeah. Because corporate attorneys aren't necessarily the right people. They concentrate on documents and taxes. That's not, that's bringing a pea shooter to a tank battle. They've got some information on that specialty, but we need the big guns. My favorite one is do not publicize. You make the decision. You can't publicize. Oh my goodness. You just talked to 5 of the employees in your restaurant. Shh, don't tell anyone. It's high school in our restaurants. The rumor mill goes whoosh. But you got to do your very, very best, because if they do start talking, what kind of harassment will you be guilty of? Retaliation. Last on this, hold meetings with supervisors and managers to review policies. You need to be doing this all the time. If a violation happens and somebody's terminated, you don't tell anybody, but once a month, you should be pointing to your bulletin board, your employer notices, and your harassment policy should be there, and you should be reminding everybody that it's important, that we follow it, and they should read it. In your employee manuals, your harassment policy, share with a signature page that they have read and understand. And then your managers need to walk the talk. Man, did the restaurant business just become a downer?
Yeah, what's the good news?
It's no good news. I'm telling you, one of the things that Michelle said is, well, what about it when you've been harassed by your employee? I terminate them. Not if I have a policy in place and I've documented what it was. And here's the bottom line. I told you, I hugged, I joked, I had a blast, I did voices. I'd be in deep trouble today with what I know now. We took over this restaurant in the chain that I work. I actually took over the restaurant as we took it over. I was in a director of operations at the time. Bartenders, servers come up, they'd hug me, and I would put my arms down at my side, and I would start to get so uncomfortable. Not only because of what I know, because the EEOC, it was the property that we took over, the EEOC was still investigating. I'm going, SOB, no way, get away, okay, super, let go. And I'm somebody who's touchy-feely, huggy, and I mean nothing by it. You could literally, there are lawsuits. I don't have them here with me now. There are other lawsuits I've given you so you can read and use as a training tool with your employees. All you got to do is go on the EEOC's website and download all of them. Doesn't take much to go find them. There's new ones. You could be in a server alley. You could be in a back bus station. Try and reach by somebody and whoops, your hand literally accidentally slips. It's the back of your hand, hits a person's rear end, and you can be sued because they're uncomfortable. Even though it was an accident. Understand, it has nothing to do with intent. It has to do with I am personally offended. And then it's up to a jury of my peers of whether you're right or I'm right. Let's go back to page L1. Can an employee sign a waiver behind?
You know, everybody, including employees, they understand nowadays that it's, the harassment policies have gone too far, and some people have taken it to the extreme. Yes, there's a sense of protection and safety environment, but sometimes it's so way out of hand. And I mean, is there such a thing?
Not that I'm aware of, but I will tell you this. What I didn't share with you is, and this is going to be up to your jury of your peers, we know that it tends to be looser industry-wide, and you may have that on your favor in a lawsuit, that, you know, it is looser in our industry. But you still, doesn't mean you're going to win. It's up to the jury of your peers that day, that lawsuit. Stacey, am I wrong to say that you bring the sexual harassment lawsuit to a trial, that it really depends on the jury? Same lawsuit, different jury, different result? Yeah. Your insurance company is not going to roll those dice most often. They're going to settle. And your rates. Oh, yeah. Oh, yeah. So, remember that EPLI insurance? That's an extra one to go over your liquor liability and your umbrella policy to cover when there's really a problem and they go for more. I want more insurance specifically for this, because liability insurance really doesn't like to pay out on this. Then they drop you. Then you go searching and you have no liability insurance for weeks until you find a company willing to insure you at astronomical rates. Been there? Know that? Uh-huh. Back to L1. A supervisor or a manager who demands sexual favors of a subordinate in exchange for tangible job benefits such as hiring, promotion, job training, or job retention has committed sexual harassment. True or false? True. This type of sexual harassment is also known by the Latin phrase quid pro quo. This is when I got to take a deep breath. Vulgar or sexual comments, graphic or suggestive comments about someone's body or manner of dress, gossip or questions about someone's sexual conduct or orientation, vulgarity, inappropriate touching, and obscene or suggestive gestures, display in the workplace of sexually suggestive photographs, cartoons, graffiti, and the like, unwelcome and repeated flirtations, requests for dates, and the like, subtle pressures for sexual activity, including unwelcome but apparently sanction-free sexual advances by a supervisor to a subordinate, solicitation or coercion of sexual activity, dates or the like by implied or expressed promise of rewards or preferential treatment, etc., constitute sexual harassment. True or false? Why I read that is, isn't it a great training tool to point out all the different ways that harassment can occur in your restaurant to open your manager's eyes? A cartoon? Oh, you mean the emails that I get? The faxes. It used to be faxes, right? Somebody send you that cartoon. The fact that one of your friends sends you a cartoon, it's sitting on the fax machine, you have no idea. An employee comes by, finds it offensive because they see it, they were in your office, you're liable. Period. Start telling your friends, don't send this crap. Emails, don't use my work email. And then at work, don't check your personal email. Honestly, now you've got to restrict internet use. And make sure you put spam filters on there, and then you got to put child protection stuff in your office, because you know late at night that manager's sitting there surfing porn on your high-speed connection. And you're liable. Because when they come do an investigation, if you're not computer savvy and know to delete cookies and go through history and all these wonderful things, sitting on there is this history of dirty pictures. Even though they were never downloaded, a computer holds a graphic. You're going to be held liable.
We just started getting sexually explicit stuff, and companies trying to solicit us or stuff, and we didn't understand where it was coming from, but we think it was
Maybe that just was
our
Well,
employees in the office on our internet.
do you have an internet site with a contact by email? Contact us by email.
No, just recently,
Okay,
actually.
it could be an employee then.
Yeah.
Because here's the deal. We have our websites. David at smilebutton.com gets so much spam, and I don't sign up for anything. There's these nifty things called spiders, and they go out and they find email addresses and put it in their databases, and they sell them to these companies, and because they know it's a live address. Next, this type of sexual harassment is called what? A hostile work environment. If an individual alleges sexual harassment and is retaliated against, this is sexual harassment even if no sexual harassment occurred? True or false? True. Managers and supervisors have 3 responsibilities with regard to the following responsibilities regarding sexual harassment as outlined under Title VII of the Civil Rights Act of 1964. What are they? I'm going to tell you. Number 1, prevent sexual harassment. Write it down. 1, prevent sexual harassment. 2, take action. 3, training. Prevent sexual harassment, take action, and training. 7, an employee who alleges sexual harassment must be told what action has been taken as a result of the investigation which occurred. True or false? True. If an employee approached a supervisor or a manager about a situation which could violate Title VII, including sexual harassment, but tells the supervisor or manager that they will not give their permission for an investigation, must the supervisor or manager then take no action? You must take action. But do you go, no, I have to, the law says so? Heck no. You just go do it. You're responsible to do that. What I would tell you is the 3 responsibilities are: 1, investigate; 2, make a decision; 3, take action. Investigate, make a decision, take action. Pardon?
I think document would be one of those must things.
Documents in there, but number 9. When conducting an investigation, it is important to ask the person making the allegation what?
What solution they would expect.
What would you like to see happen out of this investigation, and why?
Make the same decision if they want.
No, you do not have an obligation. That's a good point. I don't have to do what they want me to do. But if I don't know what their expectations are and I do something drastically different, I've now opened myself up. I mean it when I talk about the EOC and you don't want them in your door. You don't want any government agency in your door. Zane?
I've got an issue with the person, and this has only happened in a case of theft, and I never fired anybody because until you're stealing from the fire. I always have another manager, or it was always my dad, or someone else sitting with me at the same table.
Zane, beautiful.
In front of the restaurant. This doesn't take place in my office, in the back room.
Let me paraphrase so everybody can hear. It's a perfect point, way to finish this up. When you are talking to any employee, hey, let me go backwards. You ever notice that in a dentist's office, you're never left alone? You know why that is? Because they've been sued because there are some wacky dentists that have sexually harassed people under sedation. Same thing goes in our brain. We need to think that we're dentist's office. And that is, you don't go in the office and close the door with anyone. You go in the office with another manager and close the door, and I wouldn't even close it, I'd keep it cracked open. Or you go out to a table, or you go outside, you go somewhere that people can see you, that you're not doing something inappropriate behind that door where it's up to he said, she said. This is where I like security cameras. Remember I told you I don't like security cameras as a prevention for theft. They don't prevent theft. However, I like security cameras for situations because nowadays you can buy a security camera system that downloads digitally on your hard drive. You can call up the minute, the second, go to a specific camera and zoom in and hear it. And you do it from home. All it is that insurance policy for this, liquor violation, you name it. That's why I like those kinds of systems. It has nothing to do with preventing theft. And so I'd put one of those cameras in my office. We don't think about that. We think, oh, I got to put it over the register. I got to put it on the line. I got to put it at my doors. What about in your office? Now, some of your managers go, well, you don't trust me. It has nothing to do with trust. It has to do with safety of my employees. And part of that is making sure I have a sex-free environment.
What happens when you have customers in your restaurant that are going at each other, not sexually, but we had a situation the other day where a man was harassing his wife, where we had to act to it.
Well, you've got the answer. If you got people yiping at each other and it creates a hostile work environment, your job is to stop it.
I called it from customers because the guy started beating up his wife in front of the restaurant and called the cops on him.
That's different than sexual harassment. That's just plain old abuse. We're going to take a 5-minute break. We've got something uplifting and exciting, and that's Cameron Carrington to talk about marketing.